Good morning. This is a video review of negligence theory. First, we'll go through the elements of negligence. Negligence is a tort law given to a body, is a name given to a body of law that addresses and provides remedies for civil wrongs not arising out of contract obligations. A person who suffers legal damages may be responsible to use tort law to receive compensation from someone who is legally responsible or liable for those injuries. Generally speaking, tort law defines what constitutes a legal injury and establishes the circumstance under which a person may be held liable for another's injury. Torts may cover intentional conducts and intentional acts and accidents. So for negligence, we're looking at a lawsuit, a civil lawsuit where the burden of proof is preponderance of the evidence, or 51%, where it's an unintentional tort. I did not intend to injure a person. I did not intend to do some act to cause harm to someone. However, I had a responsibility to protect them from harm, and somehow I failed, and that caused them harm. The greatest number of lawsuits in sport and recreation is based on negligence law. Negligence is caused by the failure to use such care as a reasonably and prudent, careful person would use under similar circumstances. Because of that, it creates an unreasonable risk of harm. We'll look at this term reasonably prudent and careful person. We are being compared to someone who is reasonably prudent and careful in similar circumstances. So if we're providing certain care to somebody, if we're providing first aid to somebody, we're going to be held to a standard of someone with our similar background. If we are an EMT, then we will have a higher responsibility, would be compared to reasonably imprudent EMTs, reasonably imprudent doctors, reasonably prudent people who faced first aid. So we're comparing ourselves to what a reasonably prudent and careful person would do in similar circumstances, not to create an unreasonable risk of harm. We'll look at the four elements of negligence. They are duty, breach, cause, and harm. Duty, breach, cause, harm. Duty, breach, cause, harm. Duty. The defendant must have some obligation or responsibility to protect the plaintiff from unreasonable risk. It's a responsibility towards others. There's a breach of duty. Somehow that defendant has failed to meet that standard that a reasonably prudent and careful person would normally do. If there's a statutory defined standard and we failed to meet it, then it's called negligence per se, that we don't have to prove that in a court of law. If a statute defined, perhaps if you have an event with 5,000 people, and every time you have an event, you need to have medical personnel and an ambulance on staff. If you have an event with 5,000 people and there's no ambulance there, you have committed negligence per se. You have breached that duty. Duty, breach, cause, harm. Cause. There has to be a connection between that breach of duty and what actual injury occurred. Has to be proximate or a legal cause. The event would not have happened but for that breach of duty. We drive cars and we have a duty to protect other people from unreasonable risk. So we are responsible to follow traffic laws and not speed and not run through red lights. So if we run through a red light, we breach the duty. We breach the standard of care that we owe other people. Now, if we run through a red light and we don't hit anybody, there's no cause of action. There's no lawsuit somebody can bring to us. If we hit somebody else's car, therefore we had a duty, we breached it, we caused that harm. And then finally, there has to be some sort of damages. There has to be some sort of injury. The injury can be to a person, to their reputation, to their property, so it has to be some sort of harm that has in fact occurred. Where is the sources of duty? The first element, duty, responsibility, obligation. We have a special relationship, coach and athlete, athletic club and patron, physical therapist and client. There's a duty to protect from exposure to unreasonable risks that may cause injury. Sometimes we voluntarily assume that duty, where we decide at the end of this big sporting event, we're going to direct traffic or we're going to coach. Now we're putting ourselves voluntarily in creating a duty where we need to hold to that reasonable prudent and careful person standard of not creating unreasonable risks. Sometimes the duty or responsibility is created by statute. An organization, an ordinance, or regulation. Football helmets must have protection pounds per square inch, or having an ambulance at football games. Some type of responsibilities that we have, certainly in terms of sport, you have an obligation to warn about hazards, maybe a recreational aspect. If we have a ski resort, we need to make sure we're putting up signs of where the snow may not be that deep, or there are trees, or duty to warn going into a baseball stadium, watch for balls and bats flying. We have an obligation to supervise others. We have an obligation to supervise our employees. We have an obligation to instruct our players, especially if those players are young. If they're 5 and 6, we have a higher level of duty to instruct them properly than we do if they're in high school or college. We have a responsibility to match competitors. We would be showing somebody an unreasonable risk of harm if we take somebody who's 7 years old, weighs 90 pounds, and has never wrestled before, and we place them against somebody who's 12 years old and is a state champion at 180 pounds. We have an obligation to provide a safe environment, safe vehicles, to inspect facilities and equipment to make sure that they are in proper condition and they fit. We have an obligation to hire qualified staff. And by qualified staff, we're not just talking about their background or their competency to manage this idea, background in physical therapy or background in recreational therapy or person who was coached before. But we have to look and go through an employment process. If we're hiring people to be directly connected to youths or women, we need to make sure that that person doesn't have a legal background where they've been found guilty of child molestation or sexual assault. That's what qualified is looking. Obligation, responsibility to provide safety equipment, to provide first aid and emergency care, to evaluate for injury or incapacity. So we have responsibilities that we have to other people. And that duty is to protect them from unreasonable harm that is foreseeable to a prudent professional. Playing an injured player, somebody with a sore hamstring, or their shoulder hurts, it's foreseeable that future injury would occur if we put them in football or baseball. If it's not foreseeable, we can't really protect against it. If there's an open and obvious danger that's not foreseeable, an individual places himself in a dangerous position, getting hit by a baseball at a baseball game tends not to be a duty, because people can appreciate and know that it becomes more of the inherent risk if it's open and obvious. The nature of the duty, the nature of the relationship between the people can change that duty, depending on if we're considering them an invitee, a licensee, or a trespasser. An invitee is a person who's on my property and I get an economic benefit from them. I charge them to be my client. I bring them into my fitness center and they pay money. They pay money to ski or do ice skate on my property. I have a 5K and they're paying me. Somehow I'm receiving an economic benefit. Therefore, my responsibility to them to protect them from unreasonable risk of harm is very great. I am responsible for something that is known as constructive knowledge. The condition is known or should have known. I have a responsibility to walk around my facility and check out everything. If there's something wrong, I need to fix it, or at the very least, I need to warn it. Because they're giving me an economic benefit, I have a duty to find out and know or should know everything that goes on in my organization. To compare that with a licensee, somebody's on my property, but I'm not getting an economic benefit from them. Maybe they're skating on my property and I'm not charging them, I'm just allowing them to do it. Or they're on my property for a party. The duty is less than the invitee. A licensee is owed the duty of being protected and warned of known defects. It's not that constructive knowledge that the invitee. I don't know and should know. I don't have a responsibility to inspect my facility, but under a licensee, if I know about it or if I'm told about it, I need to fix it. The lowest level of relationship is this idea of a trespasser, someone who's on your premises without permission. My duty is to refrain from wantonly inflicting injury on a trespasser. When I was growing up, we had a community pond behind our house that a couple different properties came up against. During the winter, it'd freeze. People would come out to that pond and they would skate on it. Oftentimes, they would have to cross over our property to get to that pond. It was one of the easiest ways to park and walk across. Now, I could put up a fence and prohibit people from doing that, from crossing my property. But what I can't do is set bear traps. So when people step on my property, it snaps and causes them harm. Even trespassers, though, there's a doctrine called the attractive nuisance. If there's something on my property that may be attractive to someone, particularly children, I need to do something to help protect them. One of the classic examples, if I have a swimming pool on my property, I need a fence around it so people don't just fall into it or walk into it, that there has to be some sort of obstacle, or a trampoline with the netting around it. An attractive nuisance, I do have some duty to protect people that are trespassers on my property. My main duty is not wantonly inflict damage to them. So now we're going to look at responsibility, duty. What is that duty? How is it created through a special relationship or voluntary assumption or statutory? And then we're going to look, what is the duty? That is something that we need to answer as we go forward with this element. Second element, breach of duty. So we have responsibility, and then we have the act, duty, breach. If the duty to protect against unreasonable harm, what is unreasonable? So we look at two different types of risks in sport and recreation. One is inherent. An inherent risk are those that are integral to the activity. You get tackled in football. You're going to get kicked in soccer. You may scrape the bottom of a swimming pool in swimming. You may get hit with a ball in baseball. These are things that are inherent to the game. By changing that and lessening it would dramatically change the sport itself. There's no liability for injury that occurs due to inherent risks that the injured party knows or should be knowledgeable about. Know, appreciate, and understand a primary assumption risk. There's also negligent behavior risks. That's conduct that is not in accord with the standard of care a prudent professional would give. So you're looking at inherent risks, and then you're looking at this negligent behavior. Behavior conducted by a person that may increase the level of risk to the participants. That's where we're going to be focused. Negligent behaviors. So ordinary negligence has a duty to use due care not to increase the risks to a participant over and above those that are inherent to the sport. Gross negligence is more than just a failure to exercise normal care. It's an act of indifference or heedless and palpable violation of law. It's a wanton, willful, or reckless disregard for the safety of others. So how would a reasonable person with similar skills and knowledge react in similar circumstances? That's the standard of care that we're looking at. So we need to know what the activity is, the types of participants. Are they young? Are they old? Are they new to the sport? Have they ever been in this situation before? What are the environmental conditions? We know this when we're driving cars. If it's snowy out, or if it's raining, or if it's dark out, the duty is, the responsibility is, our obligation is to lower our speed, to turn our lights on, to take more care. Breach of duty is the failure to conform to the standard of care. What act or what omission of an act was conducted by that person that failed to conform to that duty or responsibility. Duty, breach, cause. There has to be a reasonably close connection between conduct and the injury. Was the injury foreseeable consequence of the conduct? Just because the standard of care was not met, it doesn't mean the defendant's liable. It doesn't have to be the only factor or the only cause of the event, but it must be at least substantial. It has to be a substantial factor in the injury. Duty, breach, cause, harm, injury, damage. There must be a compensational bodily injury Emotional injury or injury to property. No damage, no liability. No harm, no injury, no liability. We look at two different types of damages. Compensatory damages. These are related to actual damages, economic loss, medical expenses, pain and suffering, emotional distress, injury to property, physical impairment. Compensatory damages, compensation, or punitive damages. These are very uncommon. These only happen when there's a gross misconduct or willful or wanton misconduct. Something that's a punishment. It's punitive. It's something to deter future transgressions. As you saw the hot coffee video, the damage award was punitive. A punitive damage creates a financial disincentive for that organization to continue behaving in that manner. There was a case in the early 70s for Ford Motor Company. They had an automobile named the Ford Pinto. And at low speed crashes, if somebody ran into the back bumper of a Pinto, the bumper would buckle, forming a point, pierce the gas tank, and oftentimes catch fire. So Ford Motor Company and got their actuaries together and they looked at this issue and they calculated how much would it cost to recall all the Ford Pintos. How much would it cost to fix the issue? We could put a brace on the bumper. We can put a brace on the gas tank where it punctures it. We could put a rubber bladder inside. We can do something to help minimize this impact. Say that Ford did the calculations and cost $10 million to do this. They also looked at what probability impact collisions would be. So say they calculated the incident and this would happen 1,000 times. And of the 1,000 times that this happened, the driver and passengers would be burned 500 times. And that lawsuit that would result would require us to pay, say, $4 million. The other 500 times that this accident would occur, the driver and passengers would die. And calculating lawsuits and how much we'd have to pay, maybe it was $3 million. So they were able to look at this purely on a monetary statute, and I'm making those numbers up just for an example. $10 million to fix the problem, $7 million to leave the problem as it is. But you still have 500 people dying and 500 people getting injured significantly. So based on a financial decision, it doesn't make sense for Ford Motor Company to bring people in and fix the problem. A punitive damage changes that financial condition. A punitive damage says, well, at $7 million to fix it, or not to fix it, somebody sues you, we're going to give them an additional $4 million. So now it's costing you $11 million to have people harmed by your negligence and $10 million to fix it. That's what punitive damage does. It punishes for the conduct and deters future transgressions. We'll look at Sanders versus Kuna and talk about different tort holdings. Nabozny versus Barnhill, one of the very earliest cases of co-participant liability. At this point, any injury in a sport would be considered inherent. Here was a sport case where they're playing soccer and Nabozny gets kicked in the head by being a goalie. And it went up on appeal, and the court here said that, you know what, there may be situations that not every injury is inherent. It depends on where that soccer ball is. If the ball is still in play and Barnhill comes up and tries to score a goal and kicks it and just happens to kick Nabozny in the head, causing injury, you know, there's no duty to prevent that. That's inherent. That's a part of the sport. To remove that would dramatically change the sport as it exists. But what happens if Nabozny has the ball in his hands? What if he has the ball and he's holding it for 30 seconds and Barnhill comes up and still kicks him in the head? This court remanded the case back to a trial level and said, you know what? Based on willful, wanton, and reckless disregard behavior of others, it may be liable. There may be liability attached between co-participants. Davidson versus the University of North Carolina. Davidson was a part of a kind of a junior varsity cheerleading squad. Does the University of North Carolina owe a duty to that group? They didn't provide them with a lot of, didn't provide them with a coach. They didn't really provide them with a lot of resources. But at what level should a university provide liability coverage for different categories of students? What parties are liable given a situation? We'll look at employees or actors, supervisory personnel, and corporations. Employees or actors, generally the person who commits the negligent act, are individually liable for their conduct. Insurance or other types of third-party coverage doesn't prevent or bar liability. It may pay out damages, but we are liable for our actions. If we commit some sort of negligent act, we should be expected to be held liable for that conduct. What about our bosses or our supervisors? What about an athletic director for coaches or a manager of different types of recreational therapists or a manager at a ski resort? Generally, administrative personnel are not liable for their negligence of their subordinates unless the administrator enhances the likelihood of injury. The administrator personally may be liable for the actions of someone else. If that hiring manager, if that athletic director or supervisor conducted or did something to enhance the likelihood of injury, we will hold them liable as well. Their duties include hiring competent personnel and discharging those who are unfit. Competent personnel, avoiding sexual assault people if they're going to run in contact with different clients or people. Not hiring somebody who has a child molestation background to coach little kids. Someone who is certified in the activity that we are hiring them for. If they're a therapist, they have that type of background. To provide proper supervision and have a plan to supervise them, to direct the services, to establish safety rules and regulations and comply with policy and statutory, to remedy dangerous conditions and fix dangerous equipments and to warn others. So there is a responsibility or a duty that supervisors have that may go in conjunction with the liable actions of others. What about the organization? So we have the actor, we have their supervisor, now we have the organization, the corporate entity. Under the doctrine of respondeat superior or vicarious liability, if the employee is acting within the scope of employment, and if the act was not grossly negligent or willful and didn't involve malfeasance, then the employer may be liable for the actions of the employees. The employer, the actual organization, not necessarily the supervisor. That would be a separate incident. We'll see this in Smith versus Gardner. And really it would be Smith versus Gardner and San Jacinto State College, but we dropped that off for the citation. But is the employee working within the scope of the employer's responsibility? Are they doing their job? And as a part of that became negligent. One reason why we have respondeat superior in this attachment of corporations, oftentimes a damage award would be so large, maybe $100,000 or more, a couple $1 million, that the person who actually conducted that act wouldn't have the financial resources to satisfy that damage award, or maybe doesn't have insurance. So this is a way that the injured party will be able to receive their compensatory damages because of the fact that the person who actually did it may not be able to provide the financial background to do it. How do we limit our liability? We can lease our facilities. We can hire independent contractors. We can indemnify ourselves. We can use waivers or assumption of risk documents by leasing the facility. It can be premise related. So we're leasing a facility from someone else, they would be responsible for the premises and making sure that all the fixtures are right and it's cleaned up and everything's warmed and the electrical is working. We're bringing an event to an arena that's owned by someone else. Maybe we're bringing our monster truck event. So the event is housed at a particular arena. That arena is responsible for a lot of the premise related liable activities. Some injuries are activity related. Those would be the people who lease the facility. If somebody's hurt in the monster truck rally, that would be attributed to me. Independent contractor. If I hire somebody who's an independent contractor, and there's very specific definitions of what that independent contractor is, that may shield my organization from liability. Do I have an employee relationship with them? Am I directing their conduct? Am I paying them directly or weekly? Or am I hiring by a particular job? Do they have their own tools? If I'm hiring an independent contractor, they're responsible specifically for their actions, and I wouldn't be liable. Independent contractors engage for a specific project, usually for a set amount of money. They can do it their own way. They can control their own work. They furnish their own equipment. Minimal regulations. An employee is hired, paid a set wage or a salary. The work is directed by the employer. Indemnification is an agreement that indemnifies, reimburses, or restores for somebody else. So maybe in the aspect that I'm leasing a facility, I'm bringing my monster truck event there, I have an indemnification agreement. If I own the facility, rather, and somebody's bringing it in, I may say, you're going to indemnify me. If I have some sort of loss due to liability caused in part by you, then you are going to be responsible for those damages. It doesn't absolve me from liability. However, it pays some of the damage award. A waiver is a contract that absolves a business for liability for negligence. It's a contract that absolves negligence, not inherent duty. And we can look at Allen versus Dover and Smith versus Gardner for some very specific applications of these. I hope this presentation helps clarify some of the confusion or at least the topic of negligence. Thanks.